Okay, good afternoon, everyone, and welcome to today's national webinar hosted by the Fellows of the American Bar Foundation. My name is Mark Suchman, and I serve as the Executive Director here at the ABF. Before we get started with the presentation today, I just want to say a few words of thanks to some of our key supporters who enable the important work that we do here at the ABF. So, first of all, we're deeply indebted, deeply grateful for the ongoing generosity of the American Bar Endowment. As many of you know, the endowment is the longtime primary funder of all the research and programming we do at the ABF, and we're immensely appreciative of their annual grant. And of course, thanks to all of you as fellows for your generous support. For more than 70 years, the ABF has pursued the mission of expanding knowledge and advancing justice through rigorous, empirical, interdisciplinary research like the work that you'll hear about in today's program. And your donations as fellows, your engagement in this community help to sustain our mission, and we are truly thankful for all that you do. One housekeeping note for today's webinar: there will be time at the end for Q&A, so please feel free to submit your questions by using the button at the bottom of your screen. We'll gather those, and then we will give them to the panelists at the end to respond to. Our program this afternoon is entitled Defying the Supreme Court: Historical Perspectives on a Looming Constitutional Crisis. And our moderator this afternoon will be Professor Lauren Robel. And before she introduces our other panelists, I just want to say a few words about Lauren herself. So Lauren Robel is the Val Nolan Professor of Law Emerita at Indiana University, where from 2002 to 2012, she was the first woman to serve as Dean of the Maurer School of Law before becoming the provost of the Bloomington campus and the executive vice president of the university from 2012 to 2021. She's a leading scholar on the federal courts. Her work has influenced national debates on procedural reform, on sovereign immunity. She has co-authored a leading case book on federal jurisdiction and lawyering in the federal courts. She's published numerous articles in top law journals, not only domestically, but internationally as well. She contributes frequently to amicus briefs for the United States Supreme Court, and beyond her written work, she's been chair of the Big Ten Academic Alliance, president of the Association of American Law Schools, and a founder of the Law School Survey of Student Engagement. So all of this has made Lauren a respected voice on law, on university governance, and on campus speech issues as well. Lauren has also been a fellow of the American Bar Foundation since 2003, and she's currently a visionary fellow. We're grateful for her support to the ABF over the years. We're lucky to benefit from her leadership as secretary of the ABF's board of directors, and we're particularly thrilled to have her join us to moderate our panel today. So thank you, Lauren, and with that, I'll turn it over to you.
Well, thank you so much, Mark, for that generous introduction, and welcome everybody. According to Just Security's litigation tracker, as of this morning, 228 cases have been filed challenging the Trump administration's actions in the last 100 days. These cases have led to sometimes tense standoffs between the executive and the judiciary on topics ranging across a broad range of matters, including the president's invocation of obscure and antique emergency powers to deport people without due process to foreign prisons for indefinite detention in countries where they're not citizens, far-reaching assertions of executive power to reshape and close independent agencies and entire executive departments that Congress had created, and to reallocate billions of dollars in funding that Congress had authorized, claims of power to revoke the concept of birthright citizenship enshrined in the Constitution's 14th Amendment since its adoption in 1868, coercive efforts to reshape universities and law firms to align with the administration's ideological preferences that raise questions under many of the Bill of Rights, and most directly the First Amendment, and orders targeting individuals by name for investigation by the Department of Justice because of their disagreement with the president's actions in the first administration. So I suspect that you, like I, have the sense of being in the middle of something dramatic and unprecedented in the history of executive power and separation of powers more generally in the US. And making this sense even more profound for lawyers is the administration's approach to the courts, which has included attacks on particular judges, slow-walking compliance with court orders, and in a few cases, the appearance of direct defiance of those orders. We have today two people supremely qualified to put these events into a broader historical and legal perspective. Christopher Schmidt is a research professor at the American Bar Foundation, a professor at Chicago-Kent College of Law, the editor of Law and Social Inquiry, and the co-director of the Institute on the Supreme Court of the United States. Chris is a renowned scholar whose research has focused on the relationship between social movements, legal institutions, and constitutional change. He's the author of numerous books, including Civil Rights in America, and is working now on a new book entitled Our Court, A New History of the United States Supreme Court, which explores the evolving relationship between the United States Supreme Court and the American people. Paul Smith is a member of the board of the American Bar Foundation, a visiting professor at Georgetown University Law Center, and the former senior vice president at the Campaign Legal Center, where he has brought decades of litigation experience to bear working with the CLC's lawyers on litigation strategies to address challenges to American democracy. Paul has argued before the United States Supreme Court 21 times, securing notable victories in cases I teach every year, such as Lawrence versus Texas and Brown versus Entertainment Merchants Association. He has been particularly active in voting rights cases before the court, and he previously served as a partner in the law firm of Jenner and Block, where he was chair of the firm's appellate and Supreme Court practice, and co-chair of the firm's election law and redistricting practice. Among his many awards is the ABA's section of Civil Rights and Social Justice's prestigious Thurgood Marshall Award for his work promoting civil rights and civil liberties. Chris, can I ask you to start by telling us how your research can illuminate this moment we find ourselves in?
Thank you so much, Lauren, for that introduction. It's great to see you. And before I get started, let me just give a big thank you to our fellows team here at the American Bar Foundation, Julia and Natalie, for putting this on. And also thank you to everyone for taking time out of your day to join us to talk about these important issues. So I have a few slides I'm going to share with you. So let me get that set up here. See that okay? Is that okay? My goal today is to draw on the past in order to illuminate the challenges of our present moment. One of the most pressing challenges that we face today is posed by a presidential administration that has threatened to defy, and perhaps has already defied, court orders that stand in the way of its policies. For those who recognize the value of constitutional checks on power and a robust commitment to the rule of law, this is not a good situation. As the Trump administration appeals its adverse lower court rulings, we may be headed toward a whole new stage of constitutional crisis, a potential scenario where the president refuses to follow a ruling of the United States Supreme Court. In my remarks today, I want to raise 2 points. The first is that defiance of mandates of the Supreme Court has happened before. Since the beginning of the Republic, people have resisted the authority of the court, and at times in our history, even the president has defied or credibly threatened to defy the court. Resistance to the authority of the court is not necessarily a bad thing. The history of the court has been, in part, a history of navigating the risk of defiance. Some level of defiance of the Supreme Court is, in fact, compatible with a functional national commitment to the rule of law. That is one of the lessons of history that I'm going to show to you. The possibility of defiance may even be beneficial to a functioning constitutional system. But, there's an important but here, the situation we seem to be headed toward today is different from what we've seen in the past in very significant and concerning ways. So let me start off by talking about the past, and then at the end of my comments, I'm going to talk about the present, and try and situate the present in the past, and emphasizing the second point here, which is that although some of the themes do have echoes in the past, I do think we're in a very different situation, or at least potentially a very different situation today. So first, turning back to our history. There is a longstanding tradition in United States history of people refusing to comply with the mandates of the court. We'll start by looking at some examples of defiance by people other than the President of the United States. Through much of the early republic, and here we're talking about the opening decades of the 1800s, state governments regularly ignored the authority of the United States Supreme Court. State acceptance of the authority of the court only grew gradually through the early 19th century. But there were still prominent exceptions that remained even after courts began to regularly follow the mandates of the Supreme Court. And of course, an example that comes to mind for a lot of people would be in the 1960s, that period sometimes summarized as massive resistance to the civil rights movement, where in fact state governments did openly try to stand up against the court. We also have examples through American history of local authorities trying to sort of fly under the radar of mandates of the court. An example I'll bring to mind here would be the early 1960s, the U.S. Supreme Court ruled mandatory school prayer unconstitutional. If you actually looked in schools across much of the country through the 1960s into the 70s and even beyond, school prayer actually was still taking place. So there are other forms of defiance by local authorities that have happened. Just that's one example. Even Congress has examples of defying, or at least sort of working their way around Supreme Court mandates. I'll give you one example here. In 1983, the Supreme Court struck down something called legislative vetoes. This is a process by which Congress can retain an oversight role over executive branch rulemaking or implementation of the policy. The court struck this down, saying, no, Congress passes a law and then hands off implementation to the executive branch and can have no role in that implementation. A legislative veto is a mechanism by which Congress could retain some role in the implementation. The court said, no, that's unconstitutional. But if you in fact look at laws passed after the court decision, Congress still passed some legislative veto mechanisms. And if you look at informal practices, Congress oftentimes did retain some oversight role in pretty much direct contradiction of the court, but this is something that continued to happen, that was basically allowed to happen for some time after that Supreme Court ruling. So the point here is that some level of defiance is actually part of American history, and has not necessarily been an aberration, particularly when you go back further in history. Now let's shift gears a little bit and look to something more closely on point to what we're talking about in terms of the situation today, and that would be defiance against the Supreme Court by presidents of the United States. I'm going to give you three examples. These are the three most famous examples from American history of presidents who ran into the Supreme Court, who tried to resist and even defy what the Supreme Court was doing. We'll start with Thomas Jefferson. The practice of judicial review by the Supreme Court was actually born in the shadow of defiance against the court by the president. The seminal case invoking the power of judicial review came in 1803 in the case of Marbury versus Madison. Every constitutional law class includes this somewhere prominently at the front end of the curriculum. And this was, in fact, a direct response to an assumption that the executive branch would defy the court. So let me just give you a little bit of background to what happened here. In early 1801, on their way out the door, the officials of the defeated Adams administration, which had just lost the 1800 election to Thomas Jefferson, pushed through a whole series of appointments. And this included the Chief Justice of the United States. John Marshall is one of these quote-unquote midnight appointments made right before they left office. He would in fact go on to serve as Chief Justice for 3+ decades. Also included in this batch of appointments that the Adams administration did on their way out the door was a justice of the peace named in Washington, D.C., named William Marbury. Now, when Jefferson and his team arrived, this took place in March back then, they actually had a pile of commissions on the desk when they got there. The commissions had been signed and sealed, but never delivered. Thomas Jefferson promptly ordered his people to throw those commissions in the trash. He had no interest in delivering through in those commissions, even though they actually had been officially signed and sealed. William Marbury wanted to become Justice of the Peace in Washington, D.C., so he sued. He sued the Secretary of State, who is James Madison, Secretary of State under Thomas Jefferson. And Marbury went to the U.S. Supreme Court and asked the court to issue a order ordering the administration to deliver his commission. Jefferson told Madison, the Secretary of State, to ignore the court, to ignore the request to appear before the court. So in fact, Marbury argued a one-sided argument because the administration refused to even appear before the court. There's some backstory here. Jefferson actually hated John Marshall. They were distant cousins. They had a lifelong animosity that would only grow during Jefferson's time in the presidency. So Madison did not defend himself in court. And it was widely understood through this whole process that Jefferson would ignore any order requiring Marbury to receive his commission. John Marshall went on with the case anyways, delivered an opinion in which he first spent some time denouncing the Jefferson administration for refusing to issue these commissions. He just said that's what they should have done, but then went on to say that the Supreme Court lacked the statutory authority to hear the particular case that Marbury was asking. Basically, lacked the statutory authority to have a hearing of original jurisdiction to issue a writ of mandamus. Basically, Marbury was in the wrong court. So he denounced the Jefferson administration, but then said that Marbury had no right to sue in this particular court and therefore basically dismissed the case. Now, the brilliance of Marbury versus Madison was that Marshall did two things. One is he asserted the right for the first time in American history of judicial review over an act of Congress, because in fact, in the process of deciding the case, he did decide about the authority of the court to rule on the constitutionality of the act of Congress. This is the act of Congress that had supposedly given the court jurisdiction over this case. But at the same time, the second thing he did is he gave Thomas Jefferson nothing to defy. Now, the key point here for our purposes is that everybody knew that if, in fact, Marshall had issued an order requiring the deliverance of the commission, Jefferson would have defied it. So the birth of this most important power the Supreme Court has of judicial review was, in fact, born in the shadow of a credible threat of presidential defiance of the Supreme Court. Next example, another famous one in American history. This is going to be moving forward in time to the mid 19th century and Abraham Lincoln. This is be Abraham Lincoln's showdown with Chief Justice Taney. Now, there's two parts to this. One has to do with a decision that Taney wrote for the court in 1857 called Dred Scott, an infamous decision, the most infamous decision the Supreme Court ever handed down, in which he ruled two things. One was he held that Black people could not be citizens of the United States, and the other is he held that Congress had no authority to ban slavery in its territories. Lincoln condemned this opinion in no uncertain terms, and he in fact offered an argument for what the nation should do in the face of what he believed to be a deeply wrong and immoral decision. He said that although he believed that this decision should be complied by the parties of the case, meaning that the person in this case, Dred Scott, was in fact still a slave and was not a citizen for purposes of this decision, he said no one else actually was beholden to follow this particular court decision, because the main parties in the suit do have a duty to comply, but he questioned whether people beyond that necessarily did. And when he gained office in 1861, he actually followed through on this belief. The Lincoln administration defied the court's ruling in Dred Scott by recognizing Black citizens in the context of the regulation of coastal ships and issuing passports. Congress passed and Lincoln signed laws abolishing slavery in the territories. Again, this is something that the court had held was unconstitutional, as well as in the District of Columbia. Phase two of the showdown between Lincoln and Taney happened to do with the issue of the suspension of habeas corpus during the Civil War. This is perhaps the most famous example of a president ignoring a direct court order. Lincoln issued an executive order in the early stages of the Civil War, suspending the right of habeas corpus, which allows individuals to challenge in court the grounds of their detention. John Merryman, a Confederate sympathizer, was arrested by the Union Army. Chief Justice Taney, he was in fact not acting as Chief Justice of the United States, but was acting in his capacity as a circuit court justice. Sometimes the justice of the Supreme Court would actually decide cases in their capacity as lower court judges. But he issued a decision that held that the executive order was unconstitutional, because he said that only Congress, not the president, had the power to suspend the writ of habeas corpus. And this is actually based on a pretty traditional commonplace reading of the suspension clause, which is located in Article 1, having to do with congressional power. Taney granted Merryman's habeas corpus petition and ordered his release. Lincoln told the military to ignore Taney, and Merryman remained in prison. Lincoln's attorney general went on to write an opinion in defending this particular policy. Lincoln gave a speech before Congress explaining his reasoning and why he followed this particular policy. And Congress would actually eventually pass legislation issuing a suspension of the writ of habeas corpus, in some ways rectifying or at least laundering the process, responding to the Taney critique, but this was only after the fact. Example 3. And it is worth noting that the presidents I'm highlighting here, these are the most famous examples, but these are also the presidents who generally rank at the top of the list of the greatest presidents in our history. So here we're moving forward in time to the 1930s and Franklin Roosevelt. So FDR, of course, famously had a number of run-ins with the court, the most famous being the court packing battle when he was frustrated with the Supreme Court that led him to push his ill-fated plan to try and pack the court with new justices. In fact, adding 6 additional justices, bringing the number up to 15, so that that court would be stacked with people that allied with his beliefs and would uphold his New Deal policies. Prior to this plan, he even privately considered proposing a law that would simply require the court to give Congress advisory opinions on federal bills and allow Congress to override any court opinions that they disagreed with. All right, so FDR did enter into office, and really throughout his time in office, did have a sharp antagonism and skepticism toward strong judicial authority and judicial supremacy over the reading of the Constitution. A few episodes in which this came to a head. One has to do with something called the Gold Clause cases. The court heard a case in which there was a challenge to administration policy regulating currency by taking the country off the gold standard. There were some indications that the court may be ready to strike down the administration's policy, and FDR actually had a speech prepared in which he denounced the court ruling as threatening the security of the nation and indicating that he would, quote, not stand idly by and permit the decision of the Supreme Court to be carried through to its logical and inescapable conclusion. It did seem like at that point he was going to announce that he wasn't going to follow the order of the Supreme Court. The Supreme Court, in fact, did uphold administration policy, and that speech was never given. Another episode involving FDR is that in 1939, the Supreme Court ruled federal wiretaps illegal. Soon after that, FDR told his attorney general to engage in wiretapping for national security purposes as we moved into World War II. Another example, again, one of the particularly famous ones, has to do with the so-called German saboteurs case. June 1942, 8 German soldiers traveled in a German submarine from occupied France and landed on the coast of the United States. They were soon discovered, detained, and sentenced to death by a military tribunal that FDR had established by executive order. One of the saboteurs was a man named Richard Curran, an American citizen who had returned to Germany to fight for the Nazis. He challenged his sentence by arguing that the tribunal was unconstitutional, and he actually had quite a good argument. There was a civil era precedent that had held that citizens cannot be tried in military courts when the civilian courts were operating. FDR let it be known to the justices of the court. This is a time where there actually was a significant amount of communication between the White House and the Supreme Court. He let it be known to justices of the Supreme Court that he would ignore any ruling countermanding his order that the saboteurs be tried by the military tribunals. The Supreme Court did, in fact, reject Curran's claim. They upheld the military tribunals, but I think most fair observers of the reasoning of the decision thought that the reasoning was pretty weak and that FDR's pressure could very well have had an effect on what the justices decided in that case. So what I've just given you here is a number of episodes of defiance of the court, highlighting the fact that it's happened. It's happened somewhat commonly, particularly back in history, and even some episodes of presidents threatening to defy or even defying the Supreme Court. Now, for my remaining time, I want to shift gears and talk about why some of the things going on today, they do have some similarities, but they're also, I think, meaningfully different in some important ways. So I'm just going to highlight a few points by what, in ways I think that it's different. One has to do with historical trends. Most of the episodes I talked about are pretty far in the rearview mirror. These happened in the past, oftentimes in the distant past. I do think many of the most robust episodes of defiance of the court, particularly the executive branch defiance of the court, really does happen in the early parts of American history. So if you're looking for a tradition of defiance, there is a dissipation of that tradition over time. And by the time you get to the second half of the 20th century into the 21st century, it really is quite uncommon, and it's much less flagrant than it was in the past. One key point you do want to bring out here is the importance of the civil rights movement to this story. I talked before about how one of the most prominent examples of state defiance of the Supreme Court was that massive resistance movement against court-ordered desegregation in various parts of Southern life. One of the lessons that the nation took from the civil rights movement was that this kind of defiance of the court was wrong, right? Just to put it bluntly, I do think the South's response to the civil rights movement did give defiance something of a bad name. After that point, anyone who defies the court risks being put up alongside George Wallace standing in the schoolhouse door. And that's really not something that anyone really wants to be in. So I do think the civil rights movement was a critical moment, uh, um, making defiance of the court look in its worst light, but also making the court and the role of the court look stronger than it had in the past. The presumption that presidents must obey court orders is simply much stronger today than it has been in the past. So I think that's an important point to start off with. Another difference in today is just how flagrant some of the, at least the threats of defiance and perhaps even some defiance are in our current moment as contrasted to some of what we saw in the past. A lot of what we're seeing today has to do with a very strong dismissive rhetoric toward judicial authority and really lack of respect for courts and challenging courts. Appearances matter when you're talking about defiance of the courts. Much of the authority of the courts is achieved through public figures acting as if they have authority. Of course, the courts famously lack the ability to tax and any kind of ability to directly enforce their decisions. There is this idea that they need to be respected, that acting out the authority is as important as the exercise of the authority. And this is why reckless talk from people in positions of power and influence about the limits of judicial authority and the possibility of defiance, whether they're going to follow through on it or not, is something that I think is distinctive to our present moment. It was just simply the episodes I talked about in the past was less flagrant in terms of how the defiance was treated. The scope of potential defiance today does seem different. The number of potential points of defiance, this is something Lauren talked about at our opening. There's just so much going on right now. There's so many possible episodes we could be facing that this is a situation that if it follows through on what we look like we're setting up for, it could have lots of moments of defiance of varying levels of seriousness. But there's so much going on. Whereas everything I talked about in the past, it really was much more targeted and episodic, right? So just in terms of the scope of what's going on is meaningfully different. This next point I'm going to label seriousness, but this is what I'm talking about here is the seriousness in which extrajudicial actors, actors outside the court, engage in the exercise of constitutional claim making. Defiant presidents of the past took their responsibility as constitutional claim makers seriously. They articulated reasoning and engaged in constitutional dialogue. I mean, go back and read Abraham Lincoln explaining why he did not agree with Taney's view on habeas corpus. Go back and read FDR's Constitution Day speech in September 1937, where he talks about the Constitution as a layman's document and not a lawyer's document. These are serious arguments. Agree or disagree, fine, but they actually were engaging on the level of the court with an interpretation of the Constitution and really asking people to sort of judge where they stood on this. I don't see this happening in our current moment in terms of there are arguments being put out there, some sort of seeming serious, some less so. But in terms of that reasoned articulation of the belief in the Constitution and why it may vary from what the court's deciding, we don't have that today like we had in the past. And the last one, and this could ultimately be the most important one, and this is Congress or the lack thereof in today's story. The threat of impeachment as a check on executive defiance of court orders has always been there in the past, right? And the idea that a president who went too far in defying a court would have that backstop was a constant check and a sort of democratically enforced check on what presidents could and could not do. And in our current moment, we just don't simply have Congress as a meaningful check on presidential authority. That was shown, I think, through the first two Trump impeachment proceedings and by the lack of Congress as a meaningful voice at the moment in response to what's going on here. We can contrast that with, say, Lincoln and the habeas situation where Congress, it wasn't about to impeach Lincoln, but they ultimately reasoned through and backed him up. So this is Congress alongside the executive branch, which is much different than simply executive branch going off on its own. I'll also bring in now an example I haven't brought up yet, but certainly should be on everyone's mind, and that's Richard Nixon. Why did Richard Nixon file the Supreme Court and turn the tapes over? Why did Richard Nixon eventually resign? Because of the threat of congressional impeachment was a real check happening there. And this is just much less evident today. So just to sum this up, defiance of the court orders has a long history in the United States. We should not sweep this history under the rug. Much of the history is bad, but not all of it. Some resistance to court authority can actually be beneficial to the system. It simply is part of what we have. But what we're looking at now is different than what we've had in the past, and we have reason to be deeply concerned.
Thank you so much, Chris. Paul, your reactions to this long history of defiance, both from the states and from various presidents.
Let me start off by saying thank you to you, Lauren, for moderating us, and to Chris for giving us that historical perspective, which really is interesting in the current context. And also thanks to the ABF for getting us together at this critical time. You know, my reaction is that it's really important to have some perspective on where we are right now in terms of the court's posture, the court's role. And one thing I wanted to add to the story is what the kind of remarkable switch in the perception of the court that has happened since the inauguration of Mr. Trump the second time. And it's important, I think, to remember where the court was, say, for the 5 years preceding this year. The court was really in a state of crisis in many ways in terms of perceived legitimacy on the part of many people in this country 4 or 5 or 6 years, as the idea was that the court had become too partisan, too conservative, had lost a sense of balance, and didn't seem to be following the usual pattern the court has of trying to at least stay in touch with what the American people thought was right and fair and basic American values, moving very aggressively to push a conservative agenda. And in many ways, what caused the sense of crisis in those days was the absence of the centrist person on the court that had always been there for the last quarter century or more, the O'Connor, the Kennedy, who every term would find 2 or 3 cases in which to side with the liberal wing of the court. We now have a 6-3 court where that kind of siding with the liberal wing doesn't seem to be happening. And so there was a great deal of hostility and efforts to try to find a way to attack the court, to change the court's path, all culminating in this last election. Then where are we now? Well, we have this, as Chris suggested, a very aggressive effort by the Trump White House to bring power into the executive branch, even through stretching the law or just outright defying the law in a whole variety of ways. And when that occurs under our system, the checks and balances are supposed to kick in. And one of them, in many ways, the most important, as Chris noted, is the Congress, which has lots of weapons it can use short of impeachment. Plus, it has impeachment itself, and we have a Congress so far that seems to be unwilling to exercise any kind of pushback against the Trump efforts to make the country much more executive-centric. And that's left the courts. So that's where these several hundred cases have come from. And all of a sudden, we have a lot of people who spent the last 5 years denouncing the court, investing a great deal of hope in the idea that hopefully the Supreme Court will this time see the concerns, see the problems, instinctively or consciously push back against what are perceived as abuses by the Trump administration. This is a very interesting moment because, of course, 6 months ago, a year ago, people thought that the Roberts Court was pretty much allied with Mr. Trump in many ways. They gave him this massive degree of immunity in the case last year. They made sure he stayed on the ballot despite the claim that he had engaged in insurrection in violation of the 14th Amendment. All of those things happened, but now we have a world in which we really are, those of us who are concerned about the path of the country are investing a great deal of hope that the court will see the need to step up. And we have seen some signs of that. The 1 a.m. order keeping the people from being shifted to Venezuela, to El Salvador a few days or a week ago was one sign. But will this hope in the Roberts Court as being the sole sort of functional check and balance really work out? It's a little hard to know. It's a little hard to predict, given the recent history of the court and their strong support for Mr. Trump and a whole variety of other contexts in previous times. One thing's for sure, the court is thinking about the same topic that Chris's work is about, defiance. They're concerned that they're going to get into a position where they flat out order the administration to do something, and the administration flat out refuses to do it. So far, while, as Lauren said, there have been some examples of things which seem like they're defiance of the court, the Trump people have all very clearly stated, no, we disagree. We're following the court order, that we just read it a different way. And the president has said numerous times in the last few weeks that we always follow the Supreme Court. So we'll see how long that lasts. But what we've seen is the Supreme Court moving very carefully to try to not aggressively get into a confrontational posture, using various procedural devices like standing, the idea that you have to be at a different court to pursue habeas, that kind of procedural thing to delay reaching the merits of cases, and see if they can sort of feel their way in the hope that in the long run, maybe they can avoid the kind of confrontation with the administration that would end up producing outright defiance, because outright defiance of the court ends up hurting the constitutional structure in most fundamental ways. It makes the court seem weak and ineffectual, and that's, given its importance in our system and given its importance in particular now, something that if you're the Chief Justice and the rest of the justices you want to avoid. But we may well end up seeing where this goes and see how this plays out. But I must say, it is really interesting to recognize that this kind of tension has been going on since Marbury versus Madison itself. And the court has at times, as Chris explained, tailored its decisions to avoid the very kind of confrontation that we're talking about occurring now. Just some thoughts. Thank you very much for letting me participate.
Thank you so much, Paul. Chris, several people have asked about the case of Andrew Jackson. Do you have a set of thoughts about his approach to the Supreme Court, and whether that the saying that he defied John Marshall to enforce his order is perhaps apocryphal, but his actual behavior, what about that?
Yeah, so one of the most famous quotes, or supposed quotes on this topic is, of course, Andrew Jackson saying John Marshall has made his decision, now let him enforce it, meaning that he has no ability to enforce his own opinion. Most historians say that he never actually said that, or at least we don't have a record of him saying that. But if you actually look at Andrew Jackson's record with the court, attitudes to the court, what he actually said on record about the court is all very much in line with that, and that he was quite skeptical toward the court, skeptical toward judicial authority. And in fact, on the decision in which he supposedly said that quote, having to do with Georgia trying to encroach on some Cherokee land, clearly Andrew Jackson and the Supreme Court was pushing back against that, basically issuing some decisions in support of tribal rights. Jackson clearly was sympathetic to Georgia and wasn't about to back up the Supreme Court on that particular issue. So yeah, Jackson could have been another one. To be honest, I just had limited time, so I had to pick and choose. So Jackson could have easily been another one to put in that. But again, another one to put in that would emphasize that this idea of defiance, executive skepticism toward judicial authority has a robust tradition. But most of that tradition is at least the strongest, I think, in the first half of our nation's history. And then I think after FDR, and particularly after the Civil Rights Movement, we do see much less of that, right? So that kind of language that Jackson used that was notable but not extraordinary in the 1830s, I think a century and a half later, that would come across quite differently because of the history we experienced since that point.
I think your point, Paul, about the lack of a center in the current court is actually quite a important and insightful one. Do you see at this point Justice Roberts or perhaps Justice Barrett trying to claim a bit of the center? And do you think that the court as an institution has to have a figure like that? Chris, historically, has the court always had a figure like that in times of crisis.
Well, I think the court does better when it has that that sense that there's a middle, and that shifting middle gives some wins for both sides of the ideological spectrum in every year. I mean, the court's been moderate conservative for a very, very long time, but throughout that period of time, if you go all the way back to Justice O'Connor, maybe even back to Justice Powell, there were always cases every term or every other term where the centrists would side with the liberals, and that changed the perception of the court on the part of the American people throughout decades. And I think it's fair to say that the Chief Justice has been trying to play that role on occasion, and has succeeded in playing that role on occasion. Deciding vote to uphold the Affordable Care Act, for example. At this moment, there does seem to be sort of a divide growing between the chief and Barrett on one hand, and the remaining four conservatives on the other hand, in terms of their willingness to try to make some alliances with the liberals. We'll have to see how far that goes. It's just an initial sort of hint at this point. Whether that really will happen, we'll have to see. I'm hoping that when we get to these really important issues, like, say, the Alien Enemies Act, that we won't have a 5-4 decision, that we'll have a much stronger decision than that, rejecting the idea that we're at war with a Venezuelan gang, and that gives the president all these extraordinary powers to ignore due process and the like. We'll just have to wait and see how that goes.
Yes, I would say a lot of it has to do with the different kind of issues we're facing. And I do think the loss of that moderate middle of the Supreme Court that Paul identified, that I think has happened in recent years, has a lot to do with the court, has a lot to do with American society. I mean, you look at American society on certain contentious divided issues, there simply is not a political middle anymore. So it's not surprising that the Supreme Court has always, in one way or another, reflected American society. So I do think that role that O'Connor, Powell played, Kennedy played, was a reflection that there was a moderate position on at least some of these issues out there, and I do think that's declining. I'll also echo Paul's concluding comment about it's very issue dependent. So I do think on a lot of the contentious cultural social issues, we don't really have as robust a middle ground as we had in past years. I hope that on basic rule of law issues, basic questions about due process accorded to individuals, that does seem to me something in which I think we have stronger agreement, broader agreement. And I am optimistic that the court on some of those issues will be assertive and, not just 5-4, I think 7-2, maybe even 9-0 on certain issues. When these issues just come down to questions of judicial authority and questions of basic constitutional rights that transcend the sort of issues that have divided us in recent years as a court.
Let me just second the idea that I think there is a good shot that the court will find some unity here on some of these things, because one of the features of the moves that Mr. Trump's administration has been making is a lot of their violations of law, that at least are perceived violations of law, are not really close calls. They're trying to assert power in a very aggressive way, and one of the ways you do that is to just do things that nobody else would have ever dreamed of doing. And you see that shutting down agencies without any kind of role of Congress. That kind of thing ought to be uniting to the court, even across its ideological range.
I do wonder if, to the whole store of devices that the court uses to avoid hitting crisis, we might historically add the movement internally in the court in times of extreme crisis, like in the face of FDR's proposed court packing plan. If the range of things that the court can do in response to direct challenges really calls on a kind of extreme creativity on the part of the court, to enable it to deflect those while still standing up for core constitutional principles. We have a question that asks really how we as lawyers can reassert the importance of separation of powers. What are things that we might be able to do as lawyers to do that?
Well, one thing I would say is it's the lawyers who have brought these 200 and some cases that Lauren, you talked about at the beginning. And it's other lawyers who are the judges who are responding to them. And, you know, I think what you see here is an example of how the legal profession has stepped up. There was a lot of attention to some of these firms cutting deals with Mr. Trump, but lawyers are stepping up all over the country and challenging what they perceive as illegalities, and law firms are getting involved in those cases in many ways. And so I think speaking out is important as well. I just think the legal profession, this is a moment when all members of the legal profession need to find their voice, whether it's through actual litigation or whether it's just through communicating other ways, the importance of the rule of law and the importance of our checks and balances, separation of power system.
Yeah, so just picking up that, I think for sure litigation is important. Litigation is not only important because you might win at the end of the litigation. Litigation is a way to draw attention to certain issues. It really does help focus. So even if you end up losing these cases, having these arguments covered in the media, having lawyers articulating their arguments on the steps of courthouses as well as inside courtrooms, all these are really important opportunities to get a focused attention on the importance of these issues. I'll also put on my historian hat and just say one of the best ways in which you can demonstrate the value of the rule of law, the value of separation of powers, is simply to find episodes in history in which it served a really important role. Again, you don't need to be overly simplistic about it, because history does, it's mixed. There's plenty of situations where separation of powers has not necessarily done the right thing in the end, but I think you can say on balance, it has served critically important purposes, particularly at moments where the system is stressed, right? And when you have those moments, you can look back to past episodes, whether you're going back to the 1970s or the civil rights movement or further back, and just say that this is a value that serves us well at this time. And let's think really hard before we give up on this or be willing to accept a weakening of this system.
Let's keep that historian's hat on for a minute. There is a question about the impact of demonstrations against the administration and giving the court the confidence that a ruling against the administration will have enough popular support to be worth risking defiance. You are, among your many wonderful qualities, a historian of social movements. What do you think? What's your reaction to that observation?
Yeah, so I think the short answer is potentially yes, right? Demonstrations of democratic support for certain constitutional principles. Again, I spent a lot of time studying the civil rights era where we saw people doing this across the American South. It can ultimately have an effect. Now, the way in which it has an effect is a little bit tricky. You need to unpack it a little bit. Simply having people marching in the streets making noise, even if they're getting some sympathy from other observers, is not enough. What you need to have is demonstrations that then move people, particularly people in positions of power, whether they have economic power or political power, to start supporting that, right? So it has this sort of cascade effect. So again, the civil rights movement, you had protesters who were protesting. That protest then got attention to members of Congress, members of local legislatures and state legislatures, people in business who began to put economic pressure on other businesses. And this then built support that was manifested in the political system. That's really important. You need to have politics pushing it. And then eventually it's very clear that that message was received by members of the Supreme Court. And just, to cite the obvious example, Brown versus Board of Education handed down in 1954. In the decade following Brown, the Supreme Court did almost nothing to enforce desegregation across the South in the face of massive resistance. Resistance worked in that case. But what allowed them to ultimately come around to start enforcing that in the second half of the 1960s, it was politics, right? Politics got on board, Congress started passing laws, and that emboldened the court to then step in. So yeah, demonstrations, public pressure, particularly when it can get translated into political policy, incredibly powerful for giving the court more support to rule as I think right in the face of potential defiance. Yes.
And hopefully as well, it can revive some some actual role for the Congress in this. It is a three-legged stool after all, and we really need Congress to be willing to use the formal and informal methods it has to sort of push back on excessive executive power. And well, and there is a view that as Mr. Trump's popularity goes down and as people get into the streets, the Congress, even some of the people in the same party, may be willing to be a little bit more strong in their opposition to some of the things that are going on.
Yeah, just to jump on that, bipartisan support for constitutional principles is really important historically, right? So why did the court packing plan fail? It was an alliance of Democrats who jumped ship from FDR along with Republicans who already were quite opposed to him. Civil rights movement, the Civil Rights Act of 1964 was actually a bipartisan piece of legislation. So if you're trying to think about how you're actually going to have demonstrations and politics pushing back, it can't just be Democrats. Not if it's going to be effective, not if it's going to send a message to the court about where the American people are on these issues. It really needs to be bipartisan.
One of the questions we have is whether the Supreme Court's reticence to force a confrontation is positive or negative. The questioner notes it preserves the court's legitimacy, but to what effect? How should the justices be balancing doing justice versus preserving the court's legitimacy for some future showdown?
You know, it's only been 3 months, and they have. One of the things I think they would like to avoid is having the big showdown over one of these shadow docket things where they haven't had the full process of getting the arguments aired, having people hear the oral arguments. If we're going to get to the point where they really have to do something very dramatic and insist that Mr. Trump and his people obey the rule of law, it would be better if it came that way. And that requires some time. The court does not get cases immediately. They work their way up through the system. And then when they actually hear a case on the merits, that could take 6 months or a year. So, you know, I think the fact that they're avoiding some of these issues in the shadow docket is probably a positive thing. It's maintaining their posture, saying we're in charge ultimately of what the law is, but we're not necessarily going to be in your face about it right this second. If there are some smaller ways for us to shift things around, send people to different courts or find different plaintiffs next time, that sort of thing.
Yeah,
it's quite amazing how much of the activity so far has taken place in the court's emergency docket, as opposed to anything that is, you know, that by itself is, Chris, perhaps something that's quite different from the past. To have the level of activity that we're seeing in the court's emergency docket, as opposed to in the normal, you know, cert process.
Yeah, that creates a whole new level of pressure on the court, public attention to the court. The process historically has been quite slow, and this is an option by which they can weigh in more quickly. But the challenging thing is that, you know, on some of these really contentious issues, I don't think they're super eager to weigh in too strongly before they need to. But then, you know, it looks like they're backing off or not, you know, so there's all this reading the tea leaves before the actual court had an opportunity to fully look at that. I will say, just getting back to that question, it's such a good question. Like, is it good or bad when the court acts strategically in making constitutional decisions? And the answer is it's just so dependent. And this is a term I oftentimes use to describe the court historically. Statesmanship, right? The justices need, as an institution, to act in a statesmanlike manner because they are ultimately a political organ, right? And they function as a court, but they are a part of our constitutional system, our political system. And they need to preserve that authority, which is so critical to what they do, but they also need to be strategic, or they need to be exercise statesmanship over when they decide to exercise that authority and when they decide not to. And I have to say, in the current political environment, they're going to get a lot of attacks for not doing enough or for doing too much. So that's inevitable. But in the end, I do think the verdict of history in terms of how we look back on this particular moment is going to be looked at how well they do that balance, that really hard balance. There's no rule book here, right? That hard balance of asserting basic constitutional principles, protecting the institution of the court, but also being realistic about the situation in which they operate.
The other thing I would say is that those very, very hard calls getting made on an almost daily basis are being made not by a person, but by a committee of 9 people. And, you know, decision making by committees is often problematic in its own way. And so, you know, I'm sure there's just a ton of disagreement about this, exactly how aggressive to be. In fact, you see some of it in dissenting opinions and all. If the Chief Justice, who's a very smart guy, could make these calls himself, he might very well be more coherent. But we're going to have a kind of stop and start process for a while as they try to figure out where they are.
I think it's also important to remember the public education function of having the process play its way out in the lower courts, so that by the time the Supreme Court is actually considering a case, there have been some things that have preceded that decision that actually take seriously the constitutional arguments of the administration and respond to them, so that it's particularly important, I would think, in a period of such deep partisanship, that we take advantage of the things that make courts actually strong, which is their ability to explain, and to explain carefully, and to do it on the basis of evidence. And you're right, Paul, we're only 3 months into this. For people who are skeptics of the approach the administration is taking, which is, you know, it is quite consistent with a long history of skepticism about the restraints on executive power. This is an approach that needs that careful process, I think, in order for the country to be able to get behind it.
Well, and certainly the court has in past times relied on the lower court process to sort of educate the American people and bring them along before they touch an issue. They often wait a decade or more for example, on the issue of same-sex marriage. They were happy to just let the lower courts keep fighting that out as long as possible until they actually ended up with a conflict among the circuits and they had to address it. And by the time they did, American people were 55, 60% in favor, and the whole thing ended up being a fairly easy one for the court. That wouldn't have been true 5 or 10 years earlier.
Yeah, sometimes time is the court's best friend. There is a question that about what role, if any, the suggestion that some justices have conflicts of interest might have in this discussion.
Yeah, so maybe 2 points on that. One is that, as I alluded to before with FDR, the norms around judicial independence and isolating the court from other institutions of government are quite different today than they have been in the past. There was a free flow of information between the Roosevelt administration and several members of the court. They had conduits with reporters and people. So that kind of thing we don't have anymore. The norms have simply changed, and a lot of it has to do with, if you follow the story, like Abe Fortas, who was advising LBJ through the 1960s. He got in trouble when he tried to get elevated to chief justiceship. After that point, that kind of relationship was simply frowned upon. So it's actually different. The court is, just in matter of fact, more isolated from the executive branch than it has been in the past. And there is some concern. If you look at some of the FDR's court, the court that FDR appointed after that showdown with the court, they were pretty close to the Roosevelt administration. And I think that is a point of legitimate concern with what happened there. I don't think we'd want to replicate that today. Of course, we have a whole nother story, which is the ethics concerns related to the court in recent years. I will say, and this gets back to a point that Paul made during his opening remarks, is that a lot of the sharp critique of the court on those ethics grounds mostly came from the political left, and those have receded as people are now looking at the courts in general, and particularly the Supreme Court, as potentially the institution that's going to help stand up against positions that the left now doesn't like. So it is endlessly interesting to watch the way the sort of politics around criticism of the court and exactly what the grounds of criticisms are going to be. I honestly haven't heard a heck of a lot about the justices' ethics in recent months, as people's attention has turned to try and sort of bolster the court and giving it confidence to stand up against some of what Trump administration is doing, at least from people on the political left who were previously criticizing the court.
Couldn't agree more. Absolutely. Everything switches around when we have the kind of challenge to the system that we're facing at the moment.
Well, both of you have been wonderful. Thank you so much for your presentations and commentary and insights today. And thank you to all of our attendees today. We look forward in the future to more of these national webinars and presentations from the American Bar Foundation that address the questions about rule of law, about which the ABF has a deep expertise. Thank you.
Thank you, Lauren. Thanks, Paul.
Thanks.